Judiciary Committee this Friday morning, May 9th, and we're going to look at the latest version of S12, the sealing bill, and there's an additional changed language which you received. I just printed us separately when we get to that provision. Michelle can point out, but over to you. Thank you for being here.
Good morning. For the record, Michelle Childs, Office of Legislative Counsel, and we're looking at draft 2.2 of Committee Strikeout Amendment to S12. So I'm just going to take you through the highlighted portion. So first change is on page 15, the strikeout amendment. So this is amending the language on the petition for filing for a sealed record. You'll see subdivision 4 about if there's a stipulation filed between the respondent and the petitioner, and you'll see on line 16 just highlighted language. This was you would tweak the language in the last version at the request of the Secretary of State's office around what the petitioner is supposed to put forward with their filing in the petition, any entities that should be getting notice of the petition to seal, and you see just saying Vermont state entities. So the next change is moving on to page 22. And there's a couple places in here on that we address this issue. So you recall that there was some discussion in the committee about, under current law, it says that if someone's record is sealed, then they can answer an application for employment or things like that they don't have a record, right? And I think it was raised perhaps by some witnesses about, well, people don't really know if they get an application, do I have to disclose that sealed record or not disclose that sealed record? And so this is language on page 22 saying, and just adding to that existing language where you already say you don't have to disclose it. It's that a state entity that inquires about a person's criminal history record shall advise the person of the person's right not to disclose. And this is on the expungement, but you have a similar provision on the sealing. And so that's just to make sure that as far as the state is asking for people's records, that they're just advising people when we're asking you have a record, you don't have to disclose. So it's just letting them know about the current law. That's good. Next change is on page 24. And again, this is just where I had earlier just clarified that it's Vermont state entities that have to be listed by the petitioner when they are filing. So it's clarification there. And then you'll see at the bottom of the page, subdivision B2, and this is on the sealing, the same language that I just talked to you about if the state is asking for, if you have a record, the state would say you don't have to disclose a sealed record.
Barbara has questions.
So I have a question about the first part. Because I was thinking about, are there times that somebody has a criminal record, but they need it sent to a non-state agency? They live in another state now and are applying for a job and need well, no, it won't be listed there unless, well, it could be listed there, right? Because there are times that people are getting a work background check and they're checking a variety of places where people lived.
I think I know what you're asking.
Yeah.
Somebody out of state is asking for a copy of your criminal record. Your criminal record, if it's sealed, is not going to have that.
Right. That's true. That is a good point. Right. Thank you. Okay.
So this is really to say that if the state is saying, you're applying for a job here, have you been convicted of a crime? You do not, it's just advising people that you don't have to.
So if it gets flagged somehow by somebody lived in Vermont or committed a crime here, it got flagged by somebody else, they would just need to get a copy of it themselves and send it to whoever is thinking, no, our records show you had, committed.
The person, remember, you always have a copy of your record, and I don't know who would be asking or what circumstances to provide an official copy to that person does not list the sealed or the expunged record.
Thank you.
Just brought up a question for me. With existing criminal records, not sealed, just
Mhm.
existing criminal records, can an out-of-state entity access them in any way?
I'd have to go back. I think for different purposes, basically you guys did.
I know they can't access them just because.
Right, but you can do, and I'd have to go back and look, it's been a while, but you can get like a name, date of birth, criminal conviction record. Anybody can do that.
That's public.
Through BCIC.
Okay.
Yep. Yep. So still on page 25, everybody's favorite subsection C here. Should I talk about this instead of what's on the page?
Yeah,
Okay, so, Chair just sent everybody a copy of this proposed language that came from the state's attorneys, with a, change, so it's you kind of have to read them together because what's on the handout doesn't have the underline, like it doesn't have, the underlining and that kind of stuff. But I think what you can see is basically it's taking what you have in C in the draft that I provided you, which is that I just added the clause pursuant to the exceptions established in the subsection. So because that first lead-in language is talking about in the subdivisions, you're allowing a number of folks to have access to and use a sealed record, but the intro to C says if you're going to use it basically in open court, where therefore it's sealed and it's not just who you've granted authority to see the record, it would become potentially public in court. Then you go through this process. It's in the intro for C. And the only exception to that is subdivision 8, which is the provision where you have your own records. So you can use your own records. And you'll see in the proposal in the one-page handout is to add this underlined language, which is that if the party submits a filing that contains a sealed record or a reference to a sealed record, that filing shall be filed under seal and remain under seal unless the court permits the use of the sealed record.
Tim McManus and Judge Zone weigh in on that range as well. I think.
So now moving on to the exceptions. So moving on to page 26. So remember that at your last hearing, you made the decision around on subdivision 2, criminal justice agencies can use the criminal history record for criminal justice purposes. So broad authority there. With respect to defense attorney, added that a defense attorney may use a sealed criminal history record in representing a defendant. My understanding is that the Defender General's Office is not a criminal justice agency, and therefore you want to kind of capture this to provide that. So if criminal justice agencies can use it, the state can use it, the prosecutor can use it, then you want to kind of have the balance there, and the defense attorney can use it as well.
It still applies that if they want to use it in.
Yes.
In court, they still have to go to.
Exactly, that applies to everybody.
Yep.
Okay. Next change, very small tweak. It was just a technical is the top of page 28. You'll see the highlighted language says criminal history records. Prior to that, it just said case records, and I just need to correct that terminology. Next change is on page 34. And there's a new section 2, and this goes to the issue about letting people know that you don't have to disclose a sealed or expunged record. So this is, sometimes y'all will do something that will direct a state agency to kind of like get the word out to people because, so many things pass in a year and people may not notice, that sort of a thing. And this is just directing both the administrative branch and the judicial branch to notify their folks of the right that exists under current law to say you don't have a record if you get asked about a seal, you get asked, do you have a record? You don't have to disclose a sealed or expunged record. And so this is just like, letting the state agencies know that if they have forms for, you're applying for a job, I don't know like what it looks, it's been so long since I applied for a job here, but you apply for a job, I don't know, whether or not it asks, do you have a criminal record, things like that. This would just say on the form, clarify that when they ask, do you have a criminal record? It'll say, according to these provisions of law, you do not need to disclose an expunged or sealed record. Next change is on page 38. This is just some application language because you made an earlier decision that when it comes to deferred sentences, which are currently, those records are expunged upon successful completion of a deferred sentence. You're changing that in your bill to those records would be sealed, not expunged. And so this language is just clarifying that we would only be talking about any sentence that comes down after this act passes. So if you have somebody who's already been sentenced and, they agreed to that sentence with the understanding that their record upon successful completion would be expunged, you don't want to midstream say, oh, well, no, we're not going to do that now. Now we're going to seal it. So it would only be a prospective application. And that's it.
Questions on the latest and greatest?
Everything.
I think just going back to the exceptions section. On 25, thank you. Where are we? Page 25, the subsection C, the exceptions. So using the new language proposed in our little sheet here, we're talking about filing under seal, which could presumably be the request to use the record or the record itself. I just wonder if we should add like one word in on line 10 prior to any use or reference of the record. And that establishes that you need to somehow inform the court confidentially.
Isn't a reference a use or no?
I don't think referencing, so if I say in open court,
Oh,
I have a sealed record that I'd like to use, we start to defeat the purpose of having a sealed record. You see what I mean?
Yeah, okay. Yeah, reference to, I mean, it would kind of codify what we're talking about as far as what would happen in court is that person wanting to use it would ask for bench conferences actually, and that would make it clear.
And I don't, and I don't think it makes sense to try to like legislate how that process is. Like do you go up to the, but instead,
No, no.
yeah, if I was reading it and I was like thinking about trying to use this record and I saw a reference, I'd be like, okay, I can't actually mention that there's a sealed record in open court. I've got to do it some other way.
That's to me.
Makes sense.
Okay.
We can also have Judge Zone and Ken McManus weigh in on that as well. So let's start with Judge Zone because I think he has grandchildren to get to. We're waiting for him. So thank you for your flexibility, Judge. I really appreciate it.
My pleasure. Thank you. So I've been listening a little bit and I'll kind of go backwards. I think that Representative Goodnow's comment, I had the same reaction that Chair Lalonde did, and that is, well, isn't reference use? But I do think that putting that in there, I think it will make it clear and eliminate that concern that Representative Goodnow had, is that someone basically lets the cat out of the bag and says, Judge, we have a sealed record of this defendant or this witness we want to use, whatever it may be. So I don't have an issue with that at all. The language that Michelle talked about, we support. I think it is consistent with Rule 9 of the Rules for Public Access insofar as putting, when you make a filing ahead of time, to make that filing under seal. And so the attorneys, those who are making those filings should be already on board to understand that there's a process for that. There's also, for instance, during a hearing, if someone doesn't make a reference to it and says, Judge, can we approach? And they come up to the bench, say, we have a sealed record. We believe the witness just opened the door for us to use that. The court can have that conference. If the court believes it's necessary to leave the bench to do that, it can do that. If the court wants to do it right there, it can do that also. It has that flexibility. But what also would happen is if the court then decides, no, we're not letting this record come in, the court would have the authority under the rules of public access to seal that conference, that bench conference, and say, okay, it would make little sense to say that we've just, by you seeking to get something in and the court saying no, that suddenly what you wanted to get in is out in the public domain. That would defeat the purpose. So the public access rules provide the court the ability to address those concerns. I know that one of the questions that has also come up is where it says the party shall notify the court of the party's intent to do so, and the court shall thereafter determine whether the record may be used prior to its disclosure in the proceeding. And so the question arises, well, what's the court going to consider? Or how do we decide that? The court, when we're in trials, we address the introduction of evidence through the rules, introduction of evidence through the rules of evidence. The court would consider when it's faced with this, is the information that is sought to be utilized, is that criminal history record, is it relevant? Is it unfairly, is the probative value, in other words, is the value of what it can prove substantially outweighed by the danger of unfair prejudice, or is it cumulative, is it unnecessary, things like that. So courts already will have to consider that. The interesting thing, though, when you look at the rules of evidence at trial, it's tempting to say, well, the court needs to determine, quote, admissibility. Well, not really, because evidence that can be, information can be used that might not itself be admissible, but it's being used for a valid purpose under the rules of evidence. And for example, there's a rule of evidence that talks about refreshing someone's recollection. And you can refresh recollection with other writings, other information. And so if someone asks a question and the witness says, I don't remember, or I don't have any memory of that, theoretically, the attorney can walk up with the sealed record, hand it to him and say, don't say what's in there, but, does that refresh your recollection? And the person, the attorney then takes it back and goes, the sealed record or whatever was used is not itself admissible, but the effect of it is admissible for the individual to have their recollection refreshed. Similarly, there are times that you can cross-examine someone and offer, or even during direct examination under certain procedures, you can ask questions referencing other documents, for instance, for prior inconsistent statements. The extrinsic evidence of those prior inconsistent statements is guided by the rules of evidence, and the other statement itself may or may not come in. There's times, for instance, under the rules of evidence where the attorney asks a question, and the way the rules of evidence work, they're stuck with the answer, and they cannot use that document to say, wait a minute, this document says something different. And so I point that out because the test is not admissibility, but rather what judges would do is listen to, why do you want to use it? Consider under the information before the court, whether it's relevant, admissible. If that is there, then certainly that's a consideration, whether they're unfair prejudice or probative value. And the court would make that decision on a case-by-case basis. And so that is something that we currently do in the courts. I would suggest that the absence of definitive factors here is really not different than what we do with information that comes before us in courts now, and we're able to address them. If we did feel that implementation of these exceptions and the procedures was something that needed additional structure, the courts would have the ability to introduce discovery schedules and trial orders that might address it. The criminal rules committee could introduce rules, or we could come back to the legislature and say we think there's a statutory need for change. Any questions?
Yeah, any questions? So I have a other question not relevant to this specific item. So we've been kicking around whether to have language in the bill instructing or asking the court to update its petition forms for this, but I assume that that will be done whether we put it in statute or not. Is that my understanding?
That's correct. What would happen is if this bill, if the governor signs this bill, things immediately will get put into place where we will start updating the petitions to make sure that they conform with the statutory enactment. So I can assure you that you don't need to change that. Once that happens, we have the staff, everyone gets on that. We then also generally have it looked at by criminal oversight, but if the timing doesn't work, for instance, there was a criminal oversight meeting this morning, the next one is in the fall, we can still move ahead and make necessary changes and address it.
Yeah, I think the one main thing, there may be more, but just the idea that the petition should include a list of the state, Vermont state entities that should receive the sealed order, the order sealing a document. So, all right. So I don't think, from what I'm hearing, we don't need to have it in the legislation. Any other questions for Judge Zone? Thank you very much. I really appreciate it.
Thank you.
And, enjoy your time with the family up there. Is it Maine that you're in now?
No,
No.
Massachusetts
Oh,
today.
Massachusetts. Okay. Well, that's good.
Got that. Yeah, it's always fun. So thank
All right,
you.
thanks a lot,
Have good
Judge.
weekend.
Thank you.
Take care.
If we hear from Kim, if you could join us and weigh in on this. Thank you, Michelle.
Good morning.
Thank you for your flexibility and being able to.
Yeah, happy to trot over. Kim McManus, Department of State's Attorneys and Sheriffs. Thank you for the quick work that went on with this section. We appreciate that you took our concern of just how we would inform state's attorneys and deputy state's attorneys how to do this. We support the addition Ledge Council put in for the pursuit. I'm sorry, and we're only focused, sorry, on page 25, the exceptions. Sorry if I launched right in. We have no other comments on anything else right now. But the pursuant to the exceptions established in the subsection, I think just helps our prosecutors signal to our section what we'd be using the record for and what we'd be arguing for. And then the additional language for how to submit something before we've been given permission to use it. That just helps clarify that we don't have to do two filings necessarily. Depending on the circumstances, we may, but it just gives us some guidance. And I think that clears it up for everyone using these in a filing, just to make sure we don't accidentally violate this law when it's updated. So we appreciate the work and we think we can work with this.
Any questions?
Are you good with having reference in there too?
Yes, yeah, I think your point is well made. And again, the whole point is to not talk about it until we're allowed to talk about it. So.
Yeah.
So we're trying to get the on page 26, the defense attorney part of it right, based on the Defender General's testimony. With this language, do you think that if a Defender General, like a defense attorney, were to send a discovery request to a state's attorney that like requested disclosure of a sealed record on like a witness, do you think that this language captures that?
I believe so. Well, I guess this language would capture how they would then use that. But I think the other, again, I think 3, how they would then use that record.
Yeah.
If they're using it to represent their defendant, right? That's their criteria. But I think the other exception, and I only printed out 2 pages, but there's the discovery obligation exception.
Yeah.
Right. So that's where, again, if we have it, we already have an obligation to share exculpatory or inculpatory information.
Yeah.
So we would, if we had that,
And again, an important thing to note, when we receive the criminal history record for a case, the defense attorney gets that.
Yeah.
Right? So they're gonna see what we see as far as if there exists a record and it says sealed.
Yeah.
Like, they see that. So
Yeah.
then if they then ask for that information either from us or from the police agency,
Yeah.
I believe that that exception for the discovery obligation would cover that. And then how the defense attorney would then use it in court,
Yeah.
right, would be covered under 3. That would be my
Well, it'd
interpretation.
be, I would say, if used in court would be under C, but they could be using
C3.
it for representing the client for the plea bargaining or whatever, there could be a lot of use. All sorts of use that.
Yes, outside of court.
Right.
Yes, I believe that covers the
Right.
defense, but
I appreciate it.
Yeah, I appreciate it. Thank you.
I'm assuming we'll have Marshall back into.
I mean, Ian's reached out to him.
Okay.
I had sent him the language.
I think that this, from what his concern was, this resolves that concern. Unless we hear differently from him. But
It's been put out there, so, and we're not voting on it today, so there's time.
well, I don't know. That was my
yeah.
next, that's what my next question for folks is we'll get the version that puts in that language for on page 25. If people are fine and comfortable to vote this afternoon, we'll proceed with the vote this afternoon. Otherwise, and the only reason I'm just putting it out there as a possibility is that I know this is going to a committee of conference. I've already talked to Chair Senate Judiciary. And the sooner we can just get this out for that, the better. If there's some last minute things like happened with 109, the miscellaneous bill, we're going to be in a committee of conference, and we'll have an opportunity to, if there's something we've missed, which I'm sure we haven't been working on this for 7 years, or something. So yeah, if you could get us like the latest draft, and I will do a temperature check to see if people want to vote it this afternoon when we come back after lunch. Because at 1 o'clock, we do have witness of DCF to weigh in on the amendment and the concerns that were raised yesterday related to their language on 109. We'll either vote for that amendment or not. We won't have to vote on it but if I find out that appropriations is taking that up this afternoon, which means that it will be on the floor on Tuesday, then we also have to walk through on who's doing what parts, and Barbara needs to organize that. And we also need to vote on the amendment. But if we find out they're not dealing with it until next week, then there's not a hurry. And then we'll also do a straw poll on 98. I think we're probably pushing off page 41 till Tuesday. I have to check again with Tom on that. But so we're adjourned until 1 o'clock. So
But you're saying we're delaying it again?
we might be, yeah.
Okay.
So is everybody here this afternoon, by the way, as well? Just I know Alicia and Coach are not, but
Can we not be?
No, that's an option.
well, no, you are all independent individuals, but I just.
That's right. I tend to be here until I feel like leaving.
Well, thank you.
We have votes. I want to hear for votes.
Oh, yeah, I would like to have at
Are you
least,
vote?
at least the H98.
Are you full?